Good day to you. There is no important law of the land than the First Amendment in the United States. After all, it is the First Amendment to our Constitution, the first change to our Constitution. And many of you know the spirit of the First Amendment, but you may not know the exact wording, which is in a link that I've sent you in an email today. And that the wording for the First Amendment is that Congress shall make no law respecting an establishment of a religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, which is standing for media, the press is media, or the right of people to peaceably assemble and to petition the government for a redress of grievances. So does that law give us the right to say anything we want? Well, in essence, if you're a purist or an absolutist, as some people refer to people who try to interpret the First Amendment, you believe, yes, free speech is protected no matter what you say. Others, particularly the court, say, oh no, the First Amendment is not absolute, it's relative. It's relative because it really depends on the situation. It depends on whether speech is hate speech, or whether speech is inciting violence, or whether speech is obscene. In the case of inciting violence, that's what you see going on right now in the discussions about what happened in Washington, D.C. Were the people who assembled there simply exercising their free speech, or was there an incitement to violence? Well, many of you know the answer to that. You've decided for yourself. Others of you still may be considering the implications of that, but it speaks to how the First Amendment is at play right now in the potential second impeachment of our president. And when we look at media, we can see a lot of restrictions on media, particularly in the area of obscenity. So we're going to talk about the First Amendment today, and we're also going to develop our chapter discussion, which is on media laws. We take on our 13th chapter for the class Media Law. And I want to tell you that this is a class that will involve a lot of court cases. We're going to discuss a lot of court cases today because law can be made in many different areas of American life. It can be made by government. You have government that makes laws. Congress passes laws. The president signs for it. You also have laws that grow out of regulations. Government have bodies like the FCC, the Federal Communications Commission, which can make its own regulations about how media have to behave. And then you also have court decisions. Various court decisions can determine law also, and especially the Supreme Court, the highest court in the land. Our First Amendment is pretty special. We believe it's kind of coveted, it's protected, it's sacred in our country, because what the First Amendment does in our philosophy is it makes it possible to have a democracy. Because a democracy depends on people being informed when they exercise their opinions and their votes. And the only way for people to be informed is to hear a variety of opinions going on, even if you don't like the opposing opinions. And so the First Amendment is absolutely fundamental to having an informed public that can then exercise democracy. What we know is that the First Amendment covers speech in public settings much more than it covers media content. We're going to demonstrate that today. Let's talk now about the roots of American free speech, where it comes from. We're going to go back to the colonies once again before we were a country. And I want to just highlight something we mentioned earlier, that in the American colonies, if you wanted to be a newspaper, you had to have a license from the British Crown. In other words, you were regulated by the British Crown. And that meant that you weren't going to criticize the British Crown because then you would lose your license, right? So there's not a lot of freedom of speech there. But that started to get tested. And the first way that this idea of licensing and curtailing of freedom of speech in the media starts to get contested by what is known as the John Zenger case. John Zenger and his wife, Anna Catherine Zenger, they were independent editors and printers in New England. They were very high-status people because editors and printers were high status at that time. And among the things that they did in their publications was they accused the New York governor, William Cosby, of replacing New York Supreme Court justices with he got rid of ones that he didn't like and replaced them with people that he liked. And that's not the way that you're supposed to choose justices, right? So they accused him of doing that. And what happened? The governor threw Zenger in jail for committing libel. We're going to talk about libel later on in the class, but basically it's damaging somebody's reputation. So this court case went to trial, and the jury actually found Zenger not guilty. And they established that truth, telling the truth, is actually a defense against libel. So it was established that it was true that the governor was choosing justices based on who he liked. And that means that even if his reputation is hurt, it doesn't matter. And so Zenger was let out of jail. Okay, but we also still have limits on free speech that are occurring in other areas that are also challenged by court cases. So we've got Alien and Sedition Acts, for example. And our Congress right now is talking about sedition. How amazing is that to see sedition talked about? Because sedition is really committing treason and harm against the U.S. government. We haven't talked about that really since we were a young country, and then again after World War II when the communism scare was taking place. We've sort of just proceeded as if our government is solid, but now we actually have those charges being leveled at, of all people, a president. So suffice it to say that our country has several alien and sedition laws on the books that are designed to prevent people from committing treason against the U.S. government. There's a Scottish immigrant who suffered this. His name is James Callender, Callender, and he was thrown in jail in 1800 for criticizing President Adams and his administration. And this is what he wrote. He wrote that Adams' administration he particularly wrote that Adams is, quote, repulsive, pedant, P-E-D-A-N-T, that means kind of stupid, like a pedestrian. It comes from foot. That he's pedant, he's a gross hypocrite, and get this, an unprincipled oppressor. Now, those words by today would be laughable, right, as criticism, but in those days that was crossing a line. So what happened was he was thrown in jail. He was thrown in jail in 1800. So under a sedition act. So sedition and alien acts were used a lot during World War I, particularly also in World War II. And we still have these kinds of overtures going on today. After 9/11, the U.S. passed the Patriot Act, and the Patriot Act gives the Justice Department, among other things, the legal ability to tap your phone if you're making a phone call overseas. You call a relative in Germany, your phone can be tapped by the National Security Agency. So this is what what the Patriot Act did, and it's curtailing your free speech, curtailing your ability to speak openly and publicly. And finally, our obscenity laws, which we'll highlight a little bit later today, they stop broadcasters from saying the word fuck, even though you can hear that word just by going to a local grocery store. All right, so now let's move on to protection of individuals, and then we're going to build up some information about protection for media. So we'll start with individuals, and the first area of law that this has to do with is libel. Libel is when you unfairly and falsely hurt a person's reputation, such that they lose an opportunity for a promotion, lose their job, undergo psychological suffering to which they have to receive therapy. This is what libel is all about. And there are three components to it. One is defamation. Defamation is one component to libel law, and that has to do with a person's reputation being damaged. Secondly, is identification. Identification, that means that a person or organization has to be identified by the damaging information. You can't just say that doctors are drunks. You can't say that. Doctors are drunks and have it be libel. I mean, you can say that, but it's not going to be a libel case unless you say this specific doctor on East Brown Street is a drunk. Okay, then you're identifying. That's the second component of libel law. And the third component is publication. Publication, that means that the libelous content has to be seen by somebody else. It's not enough just to create it and keep it, on a video on your phone. You have to make that statement. It has to be seen by other people. So the media, you might imagine, they're accused quite frequently of committing libel because, especially news media, they're in the business of reporting what others are doing wrong, and sometimes they get their information wrong. So the courts have established that media can actually defend against libel cases, and here are the defenses against libel cases. We already know one defense is truth. If what is in the media story is the truth, then it is a defense against libel, even though you may have hurt somebody's reputation. Secondly, we have privilege. This is the idea that any statements made in government meetings that are not for the public made in the halls of Congress that are supposed to be kept within the halls of Congress, for example, cannot be used as a basis of a libel suit. If somebody leaks one of those statements to the media, it can't be used in a libel case. Thirdly, a defense against libel for media is opinions. You can call a sitting president, an idiot or a jerk. You're allowed to do that, and if it's an opinion, that's fine. Now, there was a court case that we want to highlight here that helped clarify media defenses against libel. It's called New York Times versus Sullivan. And what this was about was there was a civil rights group that was organized in 1960 to raise money for Martin Luther King. And what they did was they printed a full-page ad in the New York Times where they criticized the Alabama police commissioner. They criticized him for racism and for showing favor towards white people and discrimination towards African Americans. In this ad, which you can see in a link that I provided in the email, there were a lot of false statements that were made. And so the police commissioner took the New York Times to court. And this court case went all the way up to the Supreme Court. And the Supreme Court, in the lower courts, the Alabama police commissioner won his suit, and the New York Times was guilty of libel. But the New York Times appealed it. It went to the Supreme Court, and the Supreme Court overturned the decision. They reversed the decision. And they said that the outcome of false statements made in good faith are not libelous. So if you tried to get your information correctly, even though you said something false, on the whole, the ad is not a false statement, even though there are false statements made in the ad. So therefore, the New York Times is not guilty of libel. That opened up a big door for media that they can actually get things wrong and still not be subject to a libel lawsuit. And in fact, this court case also said that public figures, they have to meet a higher standard for pursuing a libel case. It's harder for a public figure to sue somebody for libel because if you're going to be a public figure, then you have to take the good with the bad. If you're going to use media to run for office and to campaign, then you also have to accept that media are going to criticize you and sometimes get things wrong. So that includes, by the way, not only elected officials, but celebrities too. Celebrities go on TV talk shows to drum up support for their films. So when they are criticized wrongly about drugs, about adultery, etc., they have to take it more than the average citizen. Now let's go on to areas of law that are important to media. The first one is invasion of privacy. This is still something that's being sorted out in the internet age with revenge porn and the ability to use a camera to zoom in on somebody's room that's on your phone. A lot of this is still being sorted out. I mean, questions like how much money do you have in the bank, or what's something stupid that you've done when you're drunk, or are you on any psychiatric medicine? I mean, those are questions that you should be able to keep private, right? Unfortunately, there are no constitutional laws that protect your privacy, but it's implied by several areas of the law, privacy law. So it's implied, first of all, by the First Amendment, which prevents government from requiring a group to release a membership list. You want to find out who's a member of the Proud Boys, for example. It's a group that's being talked about in the context of the Washington violence. You can't find that out. That's private. So we've got that's taking place because of the First Amendment. Also, the Fourth Amendment limits searches and seizures, right? That's why there has to be probable cause when you're driving an automobile. So that's also protecting your privacy. The 14th Amendment also limits the disclosure of personal information by media. There have been various court cases that have tried to protect the privacy of an individual, and they basically developed 4 areas where individuals have a right to privacy from the media. The first area is intrusion. Intrusion is kind of like when you trespass onto somebody's lawn, except it's virtual space. It's going into the space of a person's body, is showing their body parts, going into their phone. That's why the Apple iPhone, when it was seized for a massacre that took place in San Bernardino and there was information on the iPhone, the federal government demanded the iPhone release the video that was on the iPhone, and Apple said, no, we're not going to do that. It's protected, and the government lost. Luckily for the government, they found somebody who could crack open that phone. But that's what intrusion is all about, is no right for media to go in and intrude on a person's personal space. A second area that's been developed by court cases is embarrassment. You're not allowed to portray somebody falling down steps or somebody being naked, or somebody being gay, or doing other kinds of things to embarrass somebody in the media. Now, you can judge for yourself whether that's taking place or not today. A third area of privacy law is false light. False light is where you portray somebody in a light that's different than how they wanted it. So, for example, if you're a news crew and you're going out and you're shooting you're shooting video of a place where people were arrested dealing crack, and in front of that house while you're shooting that video is a college student walking home to their apartment, and you capture their likeness and their face is known, and you don't make it known that they are not part of this arrest, that could be false light. And the final area of law is misappropriation. Misappropriation is where you use a person's name or image for commercial purposes without their permission. I mean, if you take a cardboard cutout of Tiger Woods and you put it in front of your golf shop to help drum up business, you can't do that without Tiger Woods' permission. That's misappropriation. Social media is clouding privacy. It's still playing out. There are some New Jersey cases. There's a New Jersey case actually that says that if you post something to your followers on social media, on Facebook or Instagram, then you do have a right to expect that it won't be shared. So there's some privacy under New Jersey law there. However, a California court case that you can read about said that somebody who posts complaints that are then printed in a newspaper does not have privacy protection. So you can post complaints on TripAdvisor or Facebook or Snapchat, but if they're printed in a newspaper, then it's public because it's a media publication. You don't have privacy. Let's go on to the next area of law now. We're going to discuss free press / fair trial. Free press / fair trial. We've got two amendments that are coming into play here. One is the Sixth Amendment, which guarantees an impartial jury for individuals and media. And the 14th Amendment is similar. It requires an impartial jury for criminal defendants. And one of the cases that help clarify both of these amendments, right, we're trying to ensure that no matter how guilty a person seems when they go to trial, it's a fair trial. One of the court cases that tested this was the case of Sam Shepard. Sam Shepard in 1954. Dr. Sam Shepard was a medical doctor, and his wife was murdered. And when the police interviewed him, he claimed that there were nappy-headed intruders in the house who got away, and therefore they were responsible for the murder. Well, that was a racist statement. Nappy-headed intruders is trying to tap into fears of black people. It's trying to tap into flat-out racism. Well, thanks to the work of media, they did some research and found out that Dr. Shepard was actually having an affair with another woman, which could have been a motive for murdering his wife. And so once the media got wind of this, it was a circus. Everybody, Dr. Sam Shepard had an affair. It's not like it is today where people have affairs and it's not looked at as harshly. But in Dr. Sam Shepard's case, it was a big deal and it was blown up all over the media. So he was convicted. He was convicted at a lower court ruling of murder. But then the Supreme Court overturned the case, ruling that there was a carnival atmosphere that prevented him from getting a free trial. Moreover, the Supreme Court issued new rules for how future trials could be handled to ensure a fair trial. One of the rules was a gag order, which means that the judge in a case can say, media are not allowed to say anything publicly about this case until it's concluded. That's one way to ensure a fair trial, so that public opinion doesn't get influenced. Secondly, you can sequester the jury. That means you can take the jury and put them in a place where they're in a bubble and they're not getting any outside information. They're locked in a hotel room, no cell phones, no newspapers, no television, no internet, until they make their decision. Thirdly, you can postpone the trial. You can say, we need to let things die down right now. We need to wait till public temperament cools down and people have more reasoned heads. And fourthly, you can change the venue of a trial. Rather than try the person in the place where the crime was committed, you can take it elsewhere. One of the most famous cases that happened local to East Stroudsburg University was the Eric Frayne case. Eric Frayne was convicted of assassinating a state police officer outside the Swiftwater Police Barracks. And that court case was postponed because of the outrage that took place. I was teaching a class here at ESU during that time period. I was teaching broadcast journalism. We followed it every week. He went out into the woods, and he was hiding in the woods, and nobody could find him. And he was a danger, and people's houses were under surveillance to try and catch him. It was an awful time period. And One of the things that happened was to ensure that even with all the evidence that looked like he was guilty and he was convicted, his trial was postponed, and also the jury was brought in from another town, was brought in from down around Philadelphia. Another case was the Oklahoma City bombing. Timothy McVeigh was eventually put to death for that. It's supposedly the most important free press fair trial in the last 30 years. That whole trial was moved away from where the bombing took place, which was Oklahoma City, and the trial was moved to Denver, Colorado to give him a free trial. And yet another dimension of free press fair trial that is under discussion is cameras in the courtroom. Do cameras change the outcome of the trial because witnesses are afraid to appear on camera because then they can be intimidated? Or witnesses can appeal to the public and they're good looking and they get the public sympathy? These are questions that are still under discussion today. In 1937, a ban was placed on cameras in the courtroom for a court case that involved the kidnapping of a famous American hero's child, Charles Lindbergh. He flew a plane around the world. That was a big deal. In 1937, his daughter was kidnapped for ransom. Cameras were prohibited in that courtroom. But then states started to allow cameras in the courtroom, but federal courts do not. And in fact, the Supreme Court, whenever you see a court case covered there, often you see sketches on the nightly news, like cartoons showing the jurors, showing the witnesses, etc., because there are no cameras in there. Let's move on now to how the press, the media, can be controlled through law, how the press can be controlled. And we know that Congress and the courts have put restrictions on the media. Media do not enjoy the same First Amendment rights that the average citizen does in public. And to illustrate that, we're going to take a look at a court case called Cohen versus Cowles. Cohen versus Cowles, C-O-W-L-E-S, versus Cowles Media, actually, Cohen versus Cowles Media. There was a Republican campaign for governor of Minnesota that was going on, and one of the candidates, Wheelock Whitney, found out that his opponent had been arrested for theft. So during this time period, Wheelock Whitney didn't want to make that known because he would be looked at as a sleazy person employing unfair campaign tactics. So he hired a public relations person, and that would be Cohen. He hired a public relations person to reveal this info to reporters, but only if he was kept anonymous. So he wanted the information out there, but he wanted to remain anonymous. So what ended up happening was two newspapers ran the story. They ran the story and they identified Cohen anyhow. So Cohen sued and he won. He won his court case because the court ruled that you have to live up to contracts. You can't break a contract. Another court case in controlling the press was Food Lion versus ABC. Food Lion is a grocery store chain, mostly in the South. And ABC had heard through its own investigative reporting that the way that Food Lion was handling meat in the meat locker was unsanitary and was not following regulations. So what happened was two ABC reporters went to Food Lion. They applied for jobs at Food Lion. They got the jobs. They went in there with white coats and cameras hidden in their buttons, and they shot all this footage of meat being hung up and touched by people without wearing gloves and hung up longer than it's supposed to. And this caused a huge fallout. Food Lion's reputation was damaged. Food Lion sued. They sued ABC for misrepresentation, and they won. But get this. When the jury came out, here was the penalty. The jury ruled that Food Lion won the court case and that ABC would have to pay Food Lion $1. $1 for lying on their resumes. So the jury was making a statement. They were saying that technically the ABC reporters did violate law, but it was more worth it for the public to know about this information. So only $1 was going to be the fine, and it was going to be for trespassing rather than anything else. Moving on to another area of law, we're going to talk about prior restraint right now, also known as censorship. That means stopping a media company from putting out content, or the media company itself stopping media content from going out because it knows it's going to get into trouble. And one of the court cases that helped clarify this was Neer versus Minnesota. Neer versus Minnesota. Jay Neer was the publisher of the Saturday Press, which was a racist and anti-Semitic newspaper. You can look at examples of the text in that newspaper in the link that I sent you. And this newspaper was taken to court by a Jewish group, and the court ruled that the government could not suppress a publication just because it was offensive. It ruled that only a publication could have its content suppressed if it was revealing military information during a war, or if that publication published obscenity. So there are two areas where speech is restricted by this court case: war information and obscenity. Also, there's the Pentagon Papers. You can read about that in the book. The Pentagon Papers, a series of papers that were commissioned, that were representing a study commissioned by the Pentagon into the Vietnam War, which is a very unpopular war. It wasn't even called a war. It was called a conflict. And the New York Times released those papers, and the military sued the New York Times, and actually the New York Times sued the federal government and won. And the federal government lost that case because the courts ruled that publishing papers did not represent a, quote, grave and imminent danger to the public. Grave and imminent danger. Those two words will come up in future court cases deciding similar matters. Next, let's go on to free speech and students. This may be of interest of you. There was a court case in a high school setting in Minnesota, Hazelwood versus Kuhlmeyer. And basically this newspaper published a story on teenage pregnancy. It ran a story and it interviewed a bunch of young females, 16, 17, who were pregnant. And they decided they were going to run this story and keep the females anonymous. Well, the principal got word of this and said, oh no, that's not going to happen. People will still know who the females are. So he censored the newspaper. The students then sued this principal, and they lost. The courts ruled that if a media publication is part of a class, is part of a curriculum, as this newspaper was, then the university or the high school has the right to censor the newspaper. So that has grave implications for the Stroud Courier if you write for that at ESU or WESS Radio, etc. There's also the case of Bong Hits for Jesus. Bong Hits for Jesus came up in the case Morse versus Frederick in 2007, where a bunch of students stood across the school with a banner, Bong Hits for Jesus. This was before marijuana was legalized in most states. And this court case ruled that principals could actually can suspend students for promoting the illegal use of drugs through a public banner. Next up, we're going to talk about journalists going to jail. This is another way that free speech is constrained, that journalists are afraid in some countries. You can see a list of the most dangerous countries to work as a journalist in. It's dangerous in the United States to work as a journalist. For some companies, you can hear many journalists talking right now on CNN about the threats that they have received because of the way that they report on the Trump administration. I interviewed a Mexican reporter one time, and I asked him what kind of threats he's ever received, and he said he was reporting on the government one time about some inefficiencies, and he got a phone call that said, hey, we know that your daughter is going for her driver's license test tomorrow. Click. That's it. So journalists are generally, not always feeling safe. And to that end, to protect them, we have what are known as shield laws. Shield laws are state laws, and they are enacted to shield a reporter from having to reveal their sources. They don't have to tell up their sources. And some reporters have actually been thrown in jail for that. You can read about that in the book. Pennsylvania's shield law, you can read in a link that I provided right there. It's designed to protect reporters if they have information that could lead to somebody else being harmed. If you're talking about murders and you want to reveal information, you put yourself at risk. So you don't want to give up your source because that source may come to harm, and shield laws are designed to protect that. Now we're going to go into the area of obscenity. Obscenity is an area that I have expertise in because I published in this area, and I just have to say our laws are silly in this country. They're silly. I mean, they block out a lot of speech that people normally use. And believe me, I'm not a person in public who uses a lot. I don't go around, fuck this, fuck that, asshole shit. I don't talk like that. Sometimes I do if I'm mad. But I don't talk like that, but a lot of people do. And so the question is, why shouldn't they be able to talk like that on media? Is media representing real life, or is it trying to portray some idealistic version of life? And basically the courts in our country have said that no, the media are not allowed to engage in obscenity. One of the court cases that did this was Roth versus the U.S. Roth ran a business selling sexually explicit books, and he was convicted for sending those books through the U.S. Postal Service. And this court case ruled that there are 3 tests for obscenity. This is how you can tell if something's obscene. First of all, the standard for obscenity has to be set by the individual local community standards versus, using the average person. So would an average person in New York City find this to be offensive versus an average person in Boise, Idaho, for example? It's the locality that determines whether something is obscene. Secondly, the work must be taken as a whole. It must be taken as a whole. You can't simply say that one slip of the word shit in a context of critiquing government policy is, if you look at the whole thing, is the whole thing obscene? That's one of the benchmarks of obscenity. Is the work taken as a whole, or generally speaking, is obscenity throughout the whole work? Is it one blip? And lastly, does the work appeal to, here's a new word for you, prurient interests? Prurient, prurient interest. That means primal interests that you can't control. You can call it horny urges if you want to think of it that way. Does the work appeal to that? All right, so that supposedly clarified things, but probably you're already saying in your head, it still doesn't clarify things for me. So along comes another court case, Miller versus California. Miller versus out of California, built on Roth versus the U.S., but added child pornography is automatically illegal at any time. You cannot broadcast child pornography, and also added that material that happens to have a serious literary, artistic, political, or scientific value cannot be banned. It cannot be banned. One of the books that was tried to be banned was Lady Chatterley's Lover during Elizabethan England, about a female who had an affair during Victoria times. It was a serious literary work. So you cannot say that because the affair was discussed, it's obscene. And that still takes place today. I was a quote-unquote victim myself. I have a radio talk show at ESU, and on my radio talk show, I was interviewing a journalist, and I asked her, why do American journalists why don't they use profanity in their writing, sometimes as appropriate? And I gave the example of how a British journalist was reviewing a latest Madonna album, and he called it S-H-I-T. He used the word, but I spelled it on the radio. Next thing I know, I'm getting a registered letter of investigation into me from the ESU administration stating that I could be dismissed from my job for saying that. So I hired an attorney, an ex-FCC attorney, and guess what? I was found innocent. But how crazy is that? Because I spelled out S-H-I-T. So the law does distinguish between indecency and obscenity. Obscenity is allowed sometimes, if you can believe that. It's allowed from 10 at night till 6 in the morning because that's when safe harbor is. That's what it's called, safe harbor. Broadcasters are allowed to loosen their language. They can use shit, they can use ass, they can use bitch, those kinds of words. But the rest of the time could be considered indecent. So indecent material is not allowed. We know that cable and satellite and streaming, there's all kinds of stuff that would be considered obscene. They are exempt because you pay for those services per fee. So you're allowed to watch Orange is the New Black and see people having sex in a jail cell. That's no problem, and saying all kinds of swear words. But broadcast media, they're the ones that are controlled because they're free public media. They broadcast over the airwaves. So it's a very, very, I have to say, maddening to broadcasters that they are restricted in some ways. And there was an interesting case in 1999, Larry Peterman. He was the owner of a video store in Utah, and he was charged with renting obscene films. And so he was charged with obscenity. So he wanted to prove that this was ridiculous. So what he did was he decided to take adult movies and place them on a channel on television at the hotel across the street. And then he collected data on all the people that were watching adult movies at the hotel. And he took this to his court case, and the jury acquitted him. Okay, so the reason I say our laws are silly is because we have these laws in place, and what does it do? It actually encourages radio disc jockeys to be shock jocks. It encourages television programming like The Simpsons, so you can see a clip of, using swear words, but bleeping them out, or putting, a black band across somebody's breasts or their genitals when they're shown in a news report. And what happens? The mind says, I want to fill in the puzzle. If I hear a bleeped out word, I want to figure out what it is. So you're actually invited. You're actually invited by these laws to be more exposed to the robustness of the obscenity than if the word fuck had just played. It's crazy, the law to me. You're hearing my commentary. So what I'm saying here, as we've been building this discussion, is that the regulation of the media industry is much harsher on broadcasters than it is on print media, and than it is on cable broadcasters, and than it is on the internet. The next area of law that I want to talk about is copyright and fair use. You cannot just steal writing. I mean, you know from your college classes you can't plagiarize, right? You can't cut and paste and bring it in. That's stealing others' ideas. And so that's what copyright law is all about. We've got the 1998 copyright law, which protects work, and also the 1998 law and also the 2002 law. You can read about those laws in the book. Essentially, a person has a right, if they create an artistic work, to control how that work is distributed. And even after they die, their work is protected for 70 years afterwards. You can't take somebody else's song, somebody else's movie, and make money off of it unless you have permission. Now, the area of regulation is something that we want to make mention of as having been reduced. Even though laws are still pretty strict for broadcasters, it has been reduced. It used to be a lot stricter. Federal regulation used to require radio stations, for example, that they had to do news. Today, it's up to radio stations whether they want to do news. And so this has all been reduced, the regulation, but it hasn't gone away completely by a law passed in 1996. It's called the Telecommunications Act of 1996. And it did a lot of things, but the biggest thing that it did was it reduced the amount of media properties that one company could own. So you now have more radio stations owned by fewer companies, more TV stations owned by fewer companies. Right in the Lehigh Valley, you've got the iHeart Media Company. It owns 4 radio stations. And the law used to be in place so that no company could gain a corner on the market, a monopoly, and charge outrageous advertising prices or have an unfair influence over people's opinions. But because of increasing competition from media sources on the internet, on DVD, from clouds, people's phones, now broadcasters are not thought to have as much influence and as much control over the market. So the Telecommunications Act lets fewer companies own more media properties. And finally, we're going to finish up with a couple failed attempts. We have the Communication Decency Act, which was designed to regulate the internet, but it failed, even though it was prohibiting child pornography, because the internet is established as a free and open medium. There even is a dark web, right? A deep dark web that you can go onto if you know how to go onto it. I've never been onto it. And you can hire an assassin. You can buy illegal weapons. You can arrange an affair with somebody. This is the deep dark web, and that's technically allowed by law because the Communications Decency Act was struck down. Also, the Net Neutrality Act was never established, even though it was proposed. Net neutrality was the idea that everybody should have equal access to the internet. And people who are poor, people who are rich, people who are black, people who are white, people who are young, people who are old, people who live in cities, people who live in the country, should all have open, easy, high-speed broadband access. That law was struck down, saying that you cannot force internet service providers to restrict access to their networks. And so Verizon and other companies, they actually will charge you more for data uploading and data downloading during time periods where more people are using the internet. You know, it's like commuting time on the highway where the streets and the highways are more clogged because of people commuting. Same idea with the internet. Verizon is allowed to slow your internet speed down, and it goes against the principles of net neutrality. So there's a lot of material having to do with law. I went longer than I normally do today, but I really wanted to make sure that we covered these issues adequately. I hope you have a great day.